Hey, Leonard. Welcome back to the Emily Show. We have a lot to talk about this week because I've been covering trial over on the live stream channel. So if you don't have the Leonard app, make sure you get it so you don't miss a minute. There have been some wild moments in this trial so far. Plus, today we need to talk about a Bricks Minifigs settlement, stuff going on in the Murdaugh case, and a back to school story that I had to know more about. And so we're all going to explore it together because what are we doing over at Penn State? I've got some questions. So if you're ready to hear about all that, and I'm sure some more, let's get into it. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. First, yes, I am covering trial. I know, Emily, you just got back. I know. We did DCI finals. It was amazing. I cried a lot. And then back home, and then back to moving Travis into college. He is just absolutely loving it. And I think one of the number one things he's really enjoying is like the walkability of college, which is truly something I miss, where you can just like run into your friends and walk out the door and go get some food and do all the things. So he's doing great. And we do have a back to school story that we're going to get to in just a minute, but not the type of back to school story I thought I'd be covering, but we're doing it anyway. And yes, I am covering trial on the live stream channel. So if you don't have the Leonard app, make sure you get it. We have been trying out a new type of notification that you have been loving that brings you right into the video when things pop off. My biggest question in this trial for the murder of Tupac that's now happening in Las Vegas, 30 years after the shooting that killed Tupac took place, is Suge Knight going to have to testify? And it seems he's been watching the trial because he keeps giving statements on the recorded prison line to TMZ, where it seems that he's been watching the trial, but he's on the witness list. And the defendant in this case, Keffe D, wrote a book about the Tupac murder called Compton Street Legend. And in that book, he talks about the fact that when his vehicle pulled up next to the vehicle Suge Knight was driving with him and Tupac in it, he and Suge Knight locked eyes the way that like Rams lock horns. His hyperbole, not mine, and talks about the fact that an understanding passed between the two of them and Suge knew that it was on. Of course, Keffe D's story throughout the numerous recorded interviews that we've heard has been that there was an incident at the Lakewood Mall where his nephew and others got into beef with opposing gang members from Death Row Records and either pulled off somebody's chain fell, somebody's death row chain got snatched, stolen, not stolen. It seems that that part is still in dispute. But either way, there was an incident at the Lakewood Mall between Southside Compton Crips and Mob Pirus. Mob Pirus affiliated and associated with Death Row Records, Southside Compton Crips affiliated at the time with Bad Boy Records. And after that incident at the Lakewood Mall, the nephew, Baby Lane, or Orlando Anderson, was seen outside the Mike Tyson fight in Vegas and got jumped by Suge Knight, Tupac, and others. And then later that night, not very long later that night, but later that night, well, the car that Suge Knight and Tupac were in and the car that Orlando Anderson, Keffe D, and others were in crossed paths and the fatal shooting happened. We have heard multiple statements from Keffe D. More are going to come. We know that Suge Knight's on the witness list. We know that Sean Diddy, P. Diddy, Puffy, inmate number 729 Combs is on the witness list. I don't know if they will actually call him to testify, but they can. And a lot of this has been putting the idea of taking out Suge Knight and Tupac at the feet of Sean Combs, who was heading rival Bad Boy Records. And it does seem the more that we hear about what was going on, which is not new to anyone who paid attention to this case or has learned about it in the subsequent decades, that the beef between Death Row Records and Bad Boy Records is what really ramped this up. What is particularly wild about this case is A, how long has passed since it went to trial? B, the amount of talking that Keffe D did in police interviews. The fact that some of his proffers, which generally don't see the light of day unless somebody needs to testify against somebody else, are being used against him, partly because of what he said in his book. And then we're just starting to get into his media interviews where he is sitting down for docuseries. There are multiple books that come up. We've heard names of everybody from Foxy Brown, Eazy-E, NWA, Dr. Dre, Big Dre, not Dr. Dre. We've heard about Snoop Dogg, and apparently Busta Rhymes threw a drink on Keffe D at some point. It's been wild. So make sure you tune in, and trust me, if the prosecution tries to call Suge Knight in this case, I'm going to let you know in an app notification immediately, because I am so curious to see how that's going to go. But the defendant's own words are being used against him, and his book definitely precipitated that. It is a lesson in maybe don't write a book on the subject. Speaking of that, we're going to be talking a little bit about Courthouse Becky in just a few minutes. So when we're talking about don't write a book on the subject, I didn't think there would be so many examples. Keffe D, Corey Richins, Courthouse Becky. How do we have so many examples of, oh, writing a book about the thing was a bad idea? But here we are. Leonard, it's that time of year where we've shifted, or at least we have, from summer to back to school, which means everything is a little bit different at the Baker House. And I appreciate our sponsor, Hungryroot, for the flexibility it offers to our family when we need it, which literally is all the time. What you're going to love about Hungryroot is it delivers right to your door. And with over 50,000 chef creator recipes and over 1,000 grocery items, not only does it work with your life, but it works with how you want to eat, what you feel like eating, and whether you are looking for things that are vegetarian, gluten-free, or more protein. And during trial, I generally need something for breakfast that I can either eat before stream or sometimes on stream, and then something that's easy and fast for dinner. And oftentimes the breakfast burritos kind of cover me for both, because who doesn't love a breakfast for dinner? So whether you are looking for snacks for lunch boxes or a higher protein breakfast or lunch or dinner for yourself, Hungryroot absolutely has you covered. And you know, we've got a great deal for you. I know you're gonna love Hungryroot as much as I do, because their flexibility is unparalleled. And for a limited time, get 40% off your first order plus a free item in every box for life. Go to hungryroot.com/Leonard and use code Leonard. That's hungryroot.com/Leonard and use code Leonard to get 40% off your first box plus a free item of your choice in every box for life. So thank you, Hungryroot, for keeping me from being hangry Emily with nothing to eat at the end of the night. Now, let's get back to today's episode. Speaking of a bad idea, the Bricks and Minifigs settlement has finally happened. And I think that part is a good idea. The fact that it took this long is a terrible idea. And here's what is still baffling to me in the Bricks and Minifigs situation. The federal lawsuit where corporate Bricks and Minifigs is still suing Brian Mansell, Reckless Ben, and others is still ongoing. Nobody's been dropped from that lawsuit yet. So while Bricks and Minifigs has put out an official statement saying that there's a settlement, I am waiting to see names removed from this lawsuit before I say, well, at least you did it. It's probably a little bit too late to undo the damage that you've done to yourselves. And for those of you that are like Emily, Bricks and Minifigs, the Lego scandal, where Bricks and Minifig Corporate, who is the franchisor of a business that allows people to resell Lego sets, whether they are used Legos or minifigs or sets that have never been opened, and even resell new Lego sets, got into a back and forth with an individual in Oregon who had co-signed a significant Lego collection. After the corporate ownership changed hands in the store, and that's a massive like rabbit hole in and of itself, because there's a lot of questions about how it changed hands and corporate Bricks and Minifigs involvement in that. But after the store changed hands, the Lego collection that was consigned was not returned. The Lego collection was not fully paid out. And all the requests for assistance and to either pay it out or give back the sets or whatever, all of those fell on deaf ears. And it seemed that corporate Bricks and Minifigs doubled down with, well, corporate took over this location and now all of that's ours. And then a YouTuber got involved in all of this named Reckless Ben and made a investigative / we're going to do whatever it takes to try to get the Legos back / a little bit of like jackass meets punked to try to bring attention to this. And oh boy, did it, because that series blew up all across the internet with many asking the same question. Hey man, just give back the Lego. And Bricks and Minifig Corporate was like, oh, it's actually not that easy. Well, there's a bunch of photos of the Lego that were still in the store when you took it over. Why is it not that easy? So there have been lawsuits that have been going on in Oregon where this happened. There's lawsuits going on in Utah where the owners and the corporation is. There are still criminal proceedings going on with regard to Reckless Ben that we will circle back to after trial. Don't you worry. And there is still this federal RICO, yes, racketeering civil lawsuit that corporate Bricks and Minifigs and the new owners of that store up in Oregon brought against Reckless Ben and those associated with him, including the owner of the original Lego set who consigned it. And now they say they've settled, but they haven't removed anyone from the lawsuit yet. So I'm not calling this case closed until we see at least Brian Mansell released from this federal lawsuit. I mean, all of this federal lawsuit should resolve, but the settlements with Brian Mansell. Let's take a look at what Bricks and Minifigs Corporate had to say on their website, shall we? The title of this blog post from bricksandminifigs.com says, resolution reached. Bricks and Minifigs and Mansell family settle consignment of rare collection through voluntary mediation, August 19th, 2026. It says that BAM Franchising, Eamon and Matt McNeff, who are the owners of the corporate entity, Baker Salem, which is the entity that now owns the store in Oregon, Josh Johnson, Brendan Best, those are the two owners that reside in Utah but own the store after the corporate takeover up in Oregon, and the Mansell family. The Mansells are the ones who consigned the large collection of vintage Star Wars Legos and more, are pleased to announce that they have reached a comprehensive, that means of all claims, that means they should be removed from the lawsuit, a comprehensive and amicable resolution of a private civil dispute. You sued them, it doesn't make it private. Of a private civil dispute relating to the Mansell family's Lego Star Wars collection. The collection was originally consigned to a former operator of the Bricks and Minifigs Salem Keizer, Oregon store. The settlement agreement is a compromise of disputed claims. It is not an admission of liability, wrongdoing, or unlawful conduct by Bricks and Minifigs, the Mansells, or any other released party. It goes on to say that the Mansells confirm that they have been compensated by Bricks and Minifigs for the losses associated with their consignment agreement and thus are releasing all their legal claims against Bricks and Minifigs, its leadership, Baker Salem, Josh Johnson, Brendan Best, and any current Bricks and Minifigs franchisee. Bricks and Minifigs, the McNeffs, Baker Salem, Josh Johnson, Brendan Best, likewise will dismiss their lawsuit against Brian Mansell. I want to see it happen. And we have not seen it happen yet. They are not saying that they are dismissing their lawsuit against Reckless Ben and others, by the by, but I'm going to be keeping an eye on that federal docket because I want to see the notice of settlement filed on the docket, and I have not seen that yet. They go on to say that through the exchange of records and information during the legal and mediation process, the parties developed a more complete understanding of what occurred. Remember, Bricks and Minifigs had been saying that they didn't have the consignment agreement, which I found difficult to believe, and I think was proven to not be the case, but it seems they're trying to save face, though I don't know if this is going to do it. They go on to say the underlying dispute arose from a consignment contract between the Mansell family and the Salem Keizer, Oregon store. Bricks and Minifigs, Baker Salem, Josh Johnson, and Brendan Best were not parties to it. Okay, but you took over the store, so you took over the agreement, but I digress. They go on to say that the Mansell's loss arose in part from the sale, accounting, storage, and disposition of inventory by the former operator of the store. Oh, it's not our fault. Blame the owner that we did the corporate takeover on. Just blame the former owner. And there might have been bookkeeping issues here. It seems like there were some, but it also seems that when the store changed hands, there were still a number of the consigned Legos within the store. And because it was all on security video, and we've since seen that, The former owner of the store was trying to explain that there were still Lego in there that were consigned. So you can't lay all the blame at the feet of the other party. They go on to say, as part of the settlement, Brian Mansell has assigned to Bricks Minifigs his claim under the original consignment contract. Bricks Minifig may elect to pursue these claims against those responsible. Emily, what does that mean? That assignment of rights means that if Bricks Minifigs wants to go and sue the former owner of the store in Oregon, Crystal Law, then Bricks Minifigs can go after the former owners and include the breach of the contract with Mansell, if there was one, in their claims against the former owners. So they really step into the shoes of the Mansells and the Mansell parties so that any claims the Mansells could bring against the former owners, they are now allowed to bring. So that is what the assignment of rights is under the contract. And it gives perhaps Bricks Minifigs a stronger bargaining position in litigation ongoing between Bricks Minifigs and Crystal Law, former owner of the Salem, Oregon store. They are taking over any claims that Mansell would have had. They go on to say that the Mansells have agreed to provide relevant records in support of BAM's claims. So not only we're taking over any rights you may have had under this contract, but also you are going to assist us by giving us everything that you have. The parties believe this places responsibility for remedying any remaining fault with the appropriate parties, which means corporate can now go after the former owners. It goes on to say that Bricks Minifigs recognizes that the Mansell family experienced a genuine loss, obviously, prolonged uncertainty, and considerable frustration after the original contract was not properly administered by the former operator of the store and during the transition from the former operator to the replacement franchisees. By corporate, corporate was the one involved in that. It goes on to say that BAM regrets that it did not more quickly access information necessary to understand and resolve the matter. Right, because they had the information. Notice how they say access the information? It's not that they didn't have it. It seems to be that they didn't review it. They didn't look at it. Or they went, la, 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 whatever. Fabulous. They regret that they didn't take that more seriously. I bet they do. I bet they do regret it because this story has blown up in their face in a way that I don't think they ever could have anticipated. If they had just done the right thing at the beginning, then, it would have been resolved, or at least worked to resolve it. Part of the problem with this entire thing is that even if the corporate entity was like, hey, there's some confusion here, they did nothing to work to resolve it. They just kept saying, too bad, so sad. Tough, sue us then. And so the way that corporate approached this with basically an eat shit attitude made it worse. They didn't seem to work with the Mansells at all. They just kept shutting them down. So their approach in handling it was horrific. There's just no reason to do business that way. They go on to say that BAM has issued an unqualified apology to the Mansell family for the losses and pain suffered from the events surrounding the dispute. Do we get to see that, or are you just telling us that you apologized? It's an unqualified apology. We're sorry we handled this in the shittiest way possible. They go on to say that the parties recognize that many Bricks Minifigs franchises and employees had no involvement with events surrounding this dispute and hope that this resolution brings closure to everyone affected and all may return to their normal business activities and personal lives. Please, 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 please come back to our stores. And there are other franchisees that have nothing to do with this. The parties named in this settlement are the ones that are intertwined. But when the faith of the public, based on the way that you chose to deal with them, has been shaken, it's really difficult for people to want to walk back into a Bricks Minifigs store. Because what if something happens? Are they to think that someone would have their back or not? And it puts the franchisees in a really shit position. And it seems that corporate didn't really care that the way that they handled their business would have blowback on every business location And that's really unfortunate for all of the other franchise owners of Bricks and Minifigs who undoubtedly became franchise owners of Bricks and Minifigs because they enjoy Lego and they enjoy the Lego community. And their corporate entity blew it all up in their face. Talk about avoidable error. This is as easily avoidable as writing a book and detailing your involvement in a murder. One could see that this would go badly. Speaking of perhaps avoidable error, we need to talk a little bit about this story out of Penn State. I don't know if you've heard about this or not, but we're going to talk about the massive cocaine operation running out of 2 frat houses at Penn State. We're going to look at the releases from, and yes, there are 2, from the state's attorneys general. And I went through all the court documents, and I'm going to tell you exactly what blew up this entire operation. Okay, little spoiler alert. It was Venmo. It was Venmo that blew the whole thing up. I'm going to tell you how in a minute. Let's take a look at what the state attorney general had to say. And if you're like, Emily, Penn State, shouldn't they be smarter than this? Look, man, book smarts and street smarts are not the same. And they were not criming well, but they got away for it for a while and seemed to make a substantial amount of money. That money's all going to go to lawyers. It's going to go to lawyers now because they're facing significant amounts of time. The first release we are looking at is from August 17th, 2026. Attorney General Sunday, and yes, it's not on Sunday. The Commonwealth of Pennsylvania's Attorney General's name is Dave Sunday. So that's what that is. But Attorney General Sunday, State College Police announced charges against 14 people in cocaine trafficking ring involving Penn State University students and fraternities. Fraternities, plural. Students, plural. One of these individuals, not a student. We're going to talk about that. Attorney General Dave Sunday, in conjunction with State College Police Department and the 54th Statewide Investigating Grand Jury, yes, they were all indicted, announced charges against 14 people in connection to a cocaine trafficking operation involving primarily college students and 2 fraternities. In all, 13 defendants were Penn State University students at or around the time of the alleged conduct in 2023 and 2024. The 14th defendant, the father of a student, is charged with tampering with evidence and hindering the investigation. That father, by the way, lawyer, is a lawyer. Don't do that. A lot of you have asked in other cases, Emily, will the parents be charged with aiding and abetting after the fact? Were they tampering? Here it is. It's happened. We're going to keep following this case because one of the dads has been charged with tampering with evidence and hindering the investigation. We're going to dive more into this as this case gets further down the road, I promise. They say that according to the investigation and a grand jury presentment, 2 members of the organization, Agostino Abatello and Thomas Robinson, were the main suppliers for the group, making regular trips to Philadelphia and New York for large quantities of cocaine. The cocaine was cut and packaged primarily at Delta Upsilon and Sigma Chi fraternity houses. Why is Sigma Chi always involved? Like always. Primarily at Delta Upsilon and Sigma Chi fraternity houses and distributed mainly to Penn State University students. They go on to talk about the main students that were charged with the significant amount of the felony charges, including felony corrupt organizations, which I imagine is their version of RICO, conspiracy, dealing in proceeds of unlawful activity and related offenses. They also talk about 8 other students that were charged with misdemeanor possession and paraphernalia cases. Quote, this was a coordinated and highly profitable drug trafficking crew revolving around 2 senior members of the fraternities, other fraternity brothers, and pledges, the Attorney General said. In fact, according to the evidence uncovered, cutting and packaging cocaine was for some pledges an indoctrination into the fraternities. Look, man, what happened to beer pong? Cutting and packaging cocaine is not a pledge activity. What are we doing? They go on to say that law enforcement used a variety of tactics to track the individuals involved, how the cocaine was obtained, packaged, and sold. Most of the payments were made in cash or via payment apps. They're leaving out the best bit of that. We're going to get there. They go on and name everyone who was involved, including Paul Robinson, who is charged with felony tampering, hindering apprehension for taking steps to conceal evidence, including a safe containing drugs and cash, and obstructing the investigation. The cases will be prosecuted by the Office of the Attorney General Drug Strike Force section. They go on to say at the end, as all Attorney General statements say, that the defendants are presumed innocent until and unless proven guilty. And then there was an update on this the next day. And I'm showing you the booking photo of Agostino Abatello. I have seen many an internet meme. That is how this story first came to my attention, with the headlines, things like Pablo Plejkabar. And I was like, what are they talking about? And then I started reading this, and then I saw how this all was discovered. And I went, the Lawnards and I need to talk. This is an update from August 18th. Ringleader of student fraternity cocaine trafficking organization surrenders, denied bail. The Attorney General announced that the leader of the cocaine trafficking ring involving Penn State students and 2 student fraternities surrendered Tuesday morning. Agostino Abatello, 24, was arraigned by the Magistrate District Court on numerous felonies, including multiple counts of possession with intent to deliver cocaine and conspiracy. The judge denied bail at arraignment. Abatello and 13 other defendants were charged Monday morning. That's after the indictments from grand jury were unsealed. Abatello failed to appear for his scheduled arraignment Monday morning. Right. Don't do that. You're going to end up staying in custody. Everyone else is out on bail. Everyone else is out on bail. And the Attorney General made a statement after the final defendant turned themselves in, saying, "We are pleased to report that the most significant members of this cocaine trafficking organization are accounted for and will have their fair process in court. These are very serious charges, and the next steps will be preliminary hearings, which at this point are set for early September." That's my interjection from going through the court docket. Now, the question you all want to know is, Emily, how did they break up this cocaine trafficking ring through the Penn State fraternities? Well, the way they break up most drug trafficking organizations, with a side of Venmo. We're going to look briefly, and we are not going to read this whole thing, but as this case goes forward, we will dive into this more. You may see some redactions. I've redacted out home addresses and things because I redact out home addresses if it's readily apparent to me that they are residences and not things like the fraternity house or the attorney's office and what have you. Confidential informant advised that a male using the nickname T-Rob is selling large amounts of cocaine from the Delta Upsilon fraternity house. And then they have the location at 229 Locust Lane. Why is there always a locust? Anyway, 229 Locust Lane. And that T-Rob was accepting payments for cocaine via Venmo username Tom Robinson, 53. His name. They were paying him for cocaine in Venmo payments to his given government name. Sir, you're at Penn State and you thought that was a good idea? The CI, Emily, what about the CI? Yeah, I imagine that when something like the CI got arrested for whatever the CI got arrested for and was like, hey, want to hear about what's going on over at Penn State? And they were like, we're all ears, buddy. So they did database searches for Tom Robinson and then found, and I've gone through court records, found traffic violations of him, tied him and his vehicle back to the frat house, and then stopped him on a traffic violation. So they were able to use his prior traffic violation to tie him to his vehicle to his fraternity house where it was registered. And at the time of the traffic stop, Robinson had a loaded 9mm handgun in the glove compartment of his Jeep. So all of the information from the traffic stop, he did have a permit for the gun. All of the information from the traffic stop helped them start to narrow down whether this might be the Thomas Robinson who's accepting Venmo payments for coke out of the Delta Upsilon frat house. So then they started doing surveillance at the frat house, and the undercover informant obtained the Snapchat information for Robinson and started snapping him. Hey, you got some snow. That's hyperbole. I don't know if that's exactly what was in the Snapchat, but started Snapchatting about it and then started setting up drug buys at the frat house and then did drug buy after drug buy after drug buy after drug buy at the house while surveilled. And then, just wait, there's more. Let's talk about the initial arrest of Thomas Robinson. On December 13th, 2024, the affiant of this probable cause statement, which goes through an exceeding amount of undercover buys at this house. And when they do undercover buys, they recover what is sold and then they test it so they know that what's being sold is, in this case, cocaine. This is pages and pages and pages long. But when I looked at the search warrant, I was like, you've got to be joking me. No, not joking. On December 13th, 2024, the affiant and additional officers executed a search warrant. Upon entering the room, this is at the frat house, Thomas Robinson was located on the bed inside the room. He was the sole occupant of the room. Officers attempted to place handcuffs on Thomas Robinson. However, he continued to resist with his hands hidden under his body and repeatedly told officers, "I'm going to fuck you up." Through the use of a taser, officers were able to get Thomas Robinson's hands behind his back and in handcuffs. After he was in handcuffs, he told the officers that he thought they were fraternity brothers playing a prank on him. So was it when they actually tased you that's when it was like, oh, not a prank. You're not joking. Thought it was a prank. And I imagine, given how many undercover buys they did, they were not just coming in with a few officers. They were raiding this house. And given how many people can live in a frat house, this was probably a fairly significant raid. But he thought it was a joke. And then they go through what was found in the room and other narcotics that were found in the room, pills that were found in the room, etc. In addition to finding a handgun, this one a .45 caliber, more cocaine, packaging materials, scales, marijuana, ecstasy, and more. So they were raided in 2024. They were indicted in 2026. And I'm going to keep an eye on what happened. But the thing that made it easy for law enforcement to track back was that he was using his personal Venmo. And I imagine from that Venmo, they were able to get search warrants for everything connected to it, phone number, email addresses, and more. So the Penn State cocaine ring, we're going to be keeping an eye on it because I'm really curious where this is going to go. And I'm curious about what the fallout is going to be from the father that's alleged to have been involved in delaying the investigation, destruction of evidence. But we're going to have to jump into that another day because there's a lot going on with Alex Murdaugh. Leonard, a quick minute to thank our sponsor, Gusto. You know that I love partnering with companies that make things easy. And Gusto is a company that I've worked with before they started sponsoring The Emily Show, because not only did they make payroll easy, but they have so many other options, including things like HR, automatic payroll tax filing, simple direct deposits, and they'll track benefits like health benefits and workers' comp and 401ks. And you have unlimited payroll runs for one monthly price. So not only do I know that it's simplified my business, but I know it'll do the same for you. If you don't yet know what Gusto is, it's an online payroll and benefits software built for small businesses like mine and yours. It's all-in-one, remote-friendly, and incredibly easy to use, so you can pay, hire, onboard, and support your team from anywhere. I've used Gusto both as an employer and as an employee, and it's incredibly easy to go into their online portal to do things like requesting time off or taking a look at the employee handbook, and they have direct access to certified HR experts, which you know is not something you want to tackle on your own. Plus, it's quick and easy to make the switch. And Leonard, you know we have a deal for you. So if you are ready to check out Gusto for yourself, just go to gusto.com/Leonard and get 3 months free when you run your first payroll. That's 3 months of free payroll at gusto.com/Leonard, just so you don't miss it. Gusto.com/Leonard. Now, let's get back to today's episode. We have 2 updates in the Murdaugh case, one involving the courthouse Becky lawsuit and then involving criminal case, the trial part 2. We are not going to get through everything that's going on in Murdaugh today, but after the Tupac trial is over, we have a hearing that I want to go through together. Some of the stuff we're going to talk about today is from that hearing. I'm still going to cover it regardless because I want to see the arguments that are made, but the fallout was interesting to me. And those of you that have the Leonard app would have seen my update when I was traveling about the courthouse Becky lawsuit. Remember, Alex Murdaugh sued Courthouse Becky for the cost of trial number 1. And when we went through together Courthouse Becky's motion to dismiss the lawsuit, I was actually, by the end of that motion, kind of persuaded. I was like, well, Courthouse Becky's lawyer makes some really good arguments on this. And the main crux of the argument was Courthouse Becky's not the cause of Alex Murdaugh having to spend money defending himself in criminal trial number 1. There may be an argument to connect her to the cost for litigating it again in trial number 2, but in trial number 1, before any alleged, they say, before any Courthouse Becky fuckery, I say, he was already indicted, being prosecuted, and in trial. Because no matter how you look at it, the interceding of Courthouse Becky with the jurors didn't happen till midway through or later the criminal trial. And by that point, Alex Murdaugh had already paid his lawyers for the trial. They were already defending him. And that was a pretty good argument that really there's no recourse here because there's no harm to Alex Murdaugh. He would have paid for that first trial no matter what. And trial number 2 hadn't happened yet. And that's exactly what the court said. And we are looking at the court order from August 5th, 2026. And in part, the court says that the plaintiff, that's Alex Murdaugh in this case, fails the threshold requirement for standing, a showing that his injury was, quote, fairly traceable to the challenged conduct of the defendant. That's that but-for causation. Like, Alex Murdaugh would not have been harmed in the way he's alleging except for or but for Courthouse Becky's behavior. And that's just not true. He would have been going to trial number 1 no matter what Courthouse Becky did or didn't do. And then the court says, consequently, defendant is entitled to dismiss this action under Rule 12b1 because plaintiff lacks standing to assert his present claim, footnote 2. And what does footnote 2 say? Quote, plaintiff carefully avoided seeking damages for expenses related to his upcoming retrial, plainly recognizing that such a claim is not ripe. Nothing in this order should be construed to express an opinion regarding the possible merit or lack of merit of any claim based on any damages plaintiff may allege from the retrial of his murder case. So the court acknowledges again that Alex Murdaugh may have a claim for expenses related to trial number 2. Here's where I think the problem is for Team Murdaugh. I don't think there's any money. This is my speculation. I don't think there's any money for trial number 2. I think they were trying to get the funds spent on trial number 1 from Courthouse Becky, if they could, so that they could put it towards trial number 2. I don't think there's anything left to tap from Alex Murdaugh. And we've seen, when asked about who's paying for trial number 2, we've seen Dick Harpootlian turn to Jim Griffin and be like, Jim? And Jim's like, we were hired to do a job. Our job's not done yet. But even between the defense attorneys in their public statements, you can see, I think, a little bit of at least friction, if not tension, with what are we doing? Well, Jim Griffin has clearly said we were hired to do a job and that job's not done yet. So I don't think they're going to be able to show after criminal trial number 2 that Alex Murdaugh paid out of his own pocket for criminal trial number 2. So that then becomes the question of whether or not the attorneys can sue for going to trial number 2 without being paid. And I don't think they have standing for that either, because Courthouse Becky didn't make them make that decision. The attorneys have a choice whether to take up representation post trial 1 and continue representing Alex Murdaugh. He could be represented by the public defender's office. He does not have to have private counsel. So I don't think they would have standing there. And I think that puts them in quite a pickle, because you can't get the funds back from trial number 1. And if he doesn't pay for trial number 2, then you can't get funds from trial number 2. But that's not going to stop Team Murdaugh from trying, because they've already filed notice of appeal, and that notice of appeal is already docketed for the Court of Appeal. So this might be a case of chasing good money with bad, because they're going to keep fighting this. It doesn't change the facts and it doesn't change the law. And I don't see where the appellate court would change their mind on this. So I think as to Alex Murdaugh versus Courthouse Becky, they may appeal, But I think it's probably a slower road to the exact same answer, which is you can't collect your money on this one from Courthouse Becky. Try again next time. And speaking of try again next time, Alex Murdaugh and his defense team were back in court arguing a bunch of pretrial motions, including their motion to change venue. And we had talked briefly about the fact that the court asked the attorneys if they could come up with an agreement of where to change venue to. They didn't. Spoiler, they didn't come up with an agreement of where to change venue to. But the judge did agree that venue needed to be changed, and this trial would not be retried in Carleton County. Where will the retrial of Alex Murdaugh take place? We don't know yet. The court is going to make that determination. We're going to watch the attorneys argue that in court on stream another day. But the court has not yet decided which county will be hosting the Murdaugh trial part 2. Also during that hearing, there was conversation about motions in limine, whether or not Alex Murdaugh's statements from trial number 1 could be used in trial number 2. And during the entirety of the hearing, Dick Harpootlian said that Alex Murdaugh had passed a lie detector test with flying colors. Well, Creighton Waters, the prosecutor in this case, disagrees and filed a motion with the court regarding that disagreement that required Dick Harpootlian to send an email to the court apologizing for his statements. And we're going to take a look at that real quick. This was filed by Creighton Waters on August 19th, 2026. Court of General Sessions, 14th Judicial Circuit, correction of defense counsel's false statement at August 14th hearing regarding polygraph. This is not a good way to be starting off trial number 2 for defense. Introduction. The state hereby files this document and moves to correct factually inaccurate statements made by defense counsel at the hearing before this honorable court on August 14th, 2026. Defense counsel's claim on the record at the hearing that defendant Alex Murdaugh passed a SLED polygraph as to the murders, much less any governmental polygraph on the subject, is categorically false and clearly said for no other reason than to attempt to prejudice this court and the public. Footnote 1. Creighton's coming out swinging, Poot. Footnote 1, which are the South Carolina Rules of Professional Conduct 3.3a, states in part, quote, a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. They go on to say that the state filed a motion to exclude mention of any polygraph examinations at trial to preclude any prejudice from their mention before the jury, given the longstanding rule throughout the courts across the land that they are not admissible due to their subjectivity and questionable reliability. During a discussion of a polygraph given to Eddie Smith by 2 SLED examiners prior to the first trial about the murders, defense counsel Harpootlian stated the following, quote, I will tell you, Mr. Murdaugh passed a polygraph, flying colors. So the same polygrapher, so it may play a role in this trial. Video of the proceeding can be found online, and the quoted portion begins at approximately 51:02. Don't worry, we're going to watch it after the Tupac trial. When counsel Harpootlian makes the false statement that defendant Murdaugh passed the polygraph, defense's co-counsel can be observed to look at each other in a way that can only be called incredulous, and then start to whisper to one another. Footnote 2. I think Poot hyperbolaed too close to the sun. He's given to hyperbole. I think he hyperbolaed too close to the sun. However, if that's not true, it's a blatant misrepresentation to the court. Footnote 2, with a YouTube link to the video. Defense counsel's above quoted statements contain a number of verifiably false factual statements that the state is duty-bound to correct. First, defendant never submitted to a SLED polygraph before or after the first trial on any subject. Second, the 2 SLED polygraphers who examined Eddie Smith, quote, the same polygrapher as defense counsel stated, never examined defendant Alex Murdaugh at any time or on any subject. How do we go from no polygraph to passed with flying colors? Maybe here. The state has been made aware of an FBI polygraph that was given in October 2023 after the first trial of defendant. Well, that's not the same thing. This was not done with the involvement or knowledge of the Attorney General's office, and that polygraph result was first provided to the state by the FBI. The FBI! Today, August 19th, 2026. Right, because the feds don't share shit with the state. Defendant Alex Murdaugh was examined by the FBI polygrapher in October 2023 only as to whether he had hidden other assets. Where's the money, Murdaugh? Right, because the feds are chasing the money. Always. The feds aren't chasing the murder case. Remember, he was prosecuted federally for his theft from clients. The feds are chasing, hey, what can we forfeit? Is there more money? Is there a boat? Is there other assets? Where's the money, Murdaugh? Because that's what the feds are concerned with. Follow the money. It was only as to whether he had other assets and whether he had told another attorney he was stealing money, financial matters to which he pled guilty both in state and federal court. Despite that, Murdaugh failed the FBI polygraph on financial matters, with results showing defendant was trying to use possible countermeasures against the test. I have so many questions. We'll come back to it another day. Therefore, despite defense counsel Harpootlian's statement to this very court on the record, one, defendant never submitted to a law enforcement polygraph given by the same polygrapher at SLED. Two, much less to a polygraph by anyone on the murders. Three, and even though he did take an FBI polygraph solely on the financial matters. Four, he failed it. Most certainly didn't pass with flying colors. It goes on to say, when counsel for the state consulted with defense co-counsel on the matter yesterday, defense co-counsel admitted that they had no knowledge of any basis that would support the defense's statement before the court that Alex Murdaugh supposedly passed a polygraph on the matter. Conclusion, the state is now compelled to correct defense counsel's false statement into the record, as it is false as to each detail that the defendant Murdaugh was given, much less passed a polygraph on the murders with quote unquote flying colors, or that any polygraph was given by the same SLED examiner who examined Eddie Smith, or that he passed any government polygraph as to any subject, footnote 3. And then they talk about polygraphs and why they aren't used in trial or in court. They are really used as an investigative technique, not as evidence that's used in trial. So Creighton's coming out swinging in that motion, saying that this is not just a misrepresentation, but like wrong on every count, just wrong. But it's wild to me that Poot is standing up so boldly in court saying that Murdaugh passed a polygraph with flying colors. When you are in court, you cannot hyperbole too close to the sun. There is a duty of candor to the court. This is not argument. This is a misstatement of a fact. And I think that's why Poot emailed the court, which also ended up on the docket, to apologize. This is from August 20th, after the Creighton Waters filing, and says, Dear Judge McCaslin, in last Friday's motions hearing, the state argued their motion in limine to exclude any mention of polygraph in the trial. During the hearing, Your Honor ruled in the state's favor. In my argument against the state's motion, I represented to the court that the state's witness and Mr. Murdaugh's co-defendant, Curtis Eddie Smith, was administered a polygraph pursuant to a proffer agreement and failed the polygraph when asked if he killed Maggie and Paul Murdaugh. The state concedes this is true. See, he's going to make his point again, and we're going to talk about that when we go through that hearing. He says, however, I went further to state that Mr. Murdaugh was administered a polygraph by the same examiner and passed quote unquote with flying colors. I realize I mistakenly conflated several facts and my statement was incorrect. Since the court ruled no mention of polygraph would be allowed at the trial, I assume my statement had no impact on the court's disposition of this motion. I am not permitted to disclose any further details regarding any polygraph testing related to Mr. Murdaugh. My client told me that. My client told me that he passed a polygraph. That's my reading between the lines, but it's purely speculation on my part. Because when an attorney says I'm not permitted to disclose any further details, it's because of attorney-client privilege. I conflated things in my head. I want to offer my apology to both the court and the state for any confusion I may have caused. Sincerely, Richard A. Harpootlian. So that is his letter correcting the record to the court, saying that he conflated some details. But notice what he leads with. He leads with, but Eddie Smith failed a polygraph. He still leads with what he wants the takeaway to be, because of course he does. We have much more Murdaugh to cover in what happened in that hearing. And yes, we absolutely will, as this case is looking for a venue so it can go to trial maybe in the spring of 2027. This judge has said repeatedly, I don't do continuances. So if y'all are picking this date, you better be ready to ride with it. And they're already in their pretrial motions and doing their motions in limine. So it looks like trial 2 for Alex Murdaugh is likely going to be in the spring of 2027. I'm going to keep an eye on all of that. We've got about 2 more weeks of evidence, maybe a little less, in Las Vegas. So make sure that you join me as we see if Keffe D's book is going to end up getting him convicted of murder. Because right now, the number 1 through 50 pieces of evidence the state has against defendant Keffe D are the words of defendant Keffe D. And I don't know if the defense will be able to undo the strength of that, though they have a good theory of the case. I just don't know if it's going to be able to persuade the jury. Thank you for being here. Thank you for being a law nerd, and I will see you on stream soon. Take care. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.